All right, so we'll go ahead and get started. Our speaker today is Anna Street. She is an associate attorney at Tuft, Locke, Jerebeck, and O'Connell. And I will go ahead and turn things over to her.
Thank you. Okay, I'm going to share my screen and we can get started here, everyone. Um, I primarily do family law, and that I came from a background doing legal aid work, so doing a ton of work with um, victims of domestic abuse and working on protection orders. Sorry, I have my screen kind of small down here, so finding there's a share button. So uh, again, I kind of come from a background of doing those protection orders. And then when the new extreme risk protection orders came out, I started researching them and following them throughout our court system. So, an extreme risk protection order is a temporary civil order which restricts access to possession of firearms. The purpose is to restrict if there's a significant danger to others or themselves. Um, I think they're also known as red flag laws. So, and they got those names kind of because of the idea that a red flag is a warning sign. So, the idea is to prevent from disaster or de escalate situations before they happen. Extreme risk protection orders, or I'll commonly refer to them as ERPOs throughout the presentation, really help with threats of self-harm. So those situations where someone may be suicidal or going through a mental health crisis. They also help when there's threats to others, when we're thinking of domestic violence, or the other thing that comes to mind would be like neighbor disputes if there are firearms involved. Threats of mass harm. So I think of like school shootings or workplace shootings and domestic terrorism. And again, these are with when you're thinking of a situation where someone has access or has made threats related to firearms. And this is just one tool in the toolbox of things that we already have in place, right? Getting taking possession of someone's firearm really does not replace following through with arresting and prosecuting in situations where that's appropriate. If someone is going through a mental health crisis, taking away their firearm is not the only solution or option out there. There are civil commitments, 72-hour holds, things like that, that can be really beneficial in de escalating the stressful time and in the long run, putting that person in a more healthy, stable environment moving forward. The ERPO is just there to address the immediate concern of someone in a mental health crisis having possession of a firearm. And other law enforcement interventions, there's things like diversion, arresting on probable cause, things like that, that can help address some issues, but it doesn't address firearm safety concerns. I've talked to many law enforcement officers about this, and they do have safety concerns for themselves with these extreme risk protection orders because it's a situation where someone is mentally unstable or extremely violent and in possession of firearms that creates a dangerous situation for law enforcement. Um, Other and law enforcement officers have also noted the risk for retaliation if someone is cooperating with law enforcement to get them information to file an ERPO. They're only solutions for a set amount of time. So they do worry about retaliation, and that's why kind of going through the tools in the toolbox of protection orders, which I'll do next, is smart for anyone in that situation if they're working with law enforcement to help get an extreme risk protection order, help remove those firearms from someone. So when we're thinking about protection orders, there's orders for protection if there is kind of just to sum it up, a physical abuse or threats of abuse in an intimate partner relationship. And the numbers I have here on the side, it's data collected from the Minnesota Judicial Branch in 2024. As of about a week or two ago, there were 7,881 orders for protection filed in Minnesota. Harassment restraining orders are for when there is harassment or abusive situations occurring for people who are not in intimate relationships, or I guess if they are. And in Minnesota, there were 13,524 this year. And I'll just note, anecdotally, I think orders for protection in HROs, OFPs and HROs typically have similar numbers, but this year we've seen a huge spike in HROs. I'm concerned people are using them for maybe monitoring conflict versus when they're truly necessary. I think the court system has been inundated with them seeing these numbers. So just a reminder that they're a tool in the toolbox, but not the only tool and not always the right tool. Domestic abuse no contact orders, those are in criminal cases. I didn't pull those numbers necessarily. They seem to track with when there are domestic abuse charges and it's appropriate for the victim to have a no contact order. And so the extreme risk protection orders in Minnesota, as of a couple of weeks ago, there were 111. So you can see that extreme ERPOs are not being used nearly as much as orders for protection and harassment restraining orders, which is probably a good thing, right? Not every situation where there's harassment or abuse calls for removing firearms with an extreme risk protection order. There's plenty of situations where there either aren't firearms involved or that police or the victim survivor have a good idea of how to get those firearms from someone safely without a court order. I do think the interaction between these all would be very interesting to see how many extreme risk protection orders come in conjunction with another type of protection order. I think that's a really great tool to use if you're concerned about someone not turning over their firearms, but need that longer term protection on a person-to-person basis. So that brings me to some of the tools, tips for figuring out if an ERPO is your tool. Really thinking about, does this person have firearms? Are they making threats related to firearms? Is law enforcement going to be able to help you in removing these firearms, or is it way too dangerous of a situation? Or can you get those firearms in another way if they're cooperative with family members, and you don't need to get law enforcement involved? That can be the safest for everyone. Again, kind of making a safety assessment there, and running through with clients if there are other safety concerns on a longer term basis where a protection order might be necessary or a civil commitment might be necessary to make sure that that person gets on better mental standing. And ERPO is really just a fix for those firearms, and a really important tool, especially since our protection orders may prevent someone from possessing firearms, but there's no real tool in an order for protection to allow law enforcement to take those firearms from someone who might not want to get them. So an ERPO, I think, is a great tool to use in conjunction with an order for protection or harassment restraining order. So I also pulled the data from the Minnesota Judicial Branch on how petitions were filed by county. We can see that Hennepin County has a huge spike. That's not surprising at all with demographics and just knowing Hennepin County and the kind of central counties tend to be on trying out new things. They tend to do that. I think some of the maybe more surprising spikes might be Dakota or Blue Earth County. And I think that's really reassuring to see police officers and law enforcement from really a vast variety of counties trying out this as a tool. Many are coming at one or two at a time this year. And so they're dipping the toe in the water, or those might be filed by individuals. And I'll get to that data in a second. But I think any of those with the higher numbers, I'm guessing is coming primarily from law enforcement. And those ones that might have one or two might be individuals. And so who can file ERPOs? Law enforcement obviously can. And it's a great tool for law enforcement family members. And there's a specific definition for that in the statute. Guardians, again, that's specifically defined, or city or county attorneys. I think some counties are figuring out a department or an individual person that would be in charge of filing these. Law enforcement has been figuring this out, and in talking with like the sheriff's union and everything, they're getting a ton of training on this. And I think each individual county is and city is addressing it differently. So each law enforcement agency, as they become more comfortable with it and see cases come through that would be fitting, will adapt and form policies around that. But this, again, this law is very new, and I don't think any law enforcement, judicial officer, county attorney, individual attorney is feeling super comfortable knowing when and how to use these effectively. Regardless of who files, they do need to work with law enforcement, as that would be the people who will be using the search warrant to obtain those firearms from an individual. So who's filed in 2024? About, or almost exactly, 75% has been law enforcement. And I double checked with the Minnesota Judicial Branch, and this includes county attorneys or city attorneys if they're filing. So really they kind of lumped all government or law enforcement into one. And then the orange portion there would be the family members or guardians. And I think this is pretty in tune with what other states were seeing when prior to Minnesota enacting a red flag law, is that individuals were far less than law enforcement, and it shows that this is really a tool that is used by law enforcement primarily. They're going to be the leaders in this field, and regardless of if it's the one, if law enforcement is using it, they'll be the one following up and enacting it. So part of the statute also requires mental health professionals to have a role in these extreme risk protection orders. And I think that's really important, right? Because mental health professionals could be the people on the front lines here dealing with someone and knowing about someone who's having a mentally unstable moment. I think in a lot of the mass shootings we've been seeing in schools, there are warning signs, and potentially mental health professionals are seeing those warning signs before they happen. So I think that's very important. They have a duty to notify the sheriff or law enforcement, really, if they have a concern related to their client with firearms, and they need to make a recommendation on the fitness of that individual to possess a firearm. They do have some protections, and who qualifies as a mental health professional is specifically noted in the statute. So that's a bit narrow, but I think this is an kind of tapped area of the statute that we'll see how it unfolds. I think mental health professionals tend to be uncomfortable making reports about their clients, and they do it in extreme circumstances when it's warranted. So hopefully that helps people moving forward, especially if they're in those mentally unstable moments. Getting into some of the nitty gritty of what a judicial officer needs to see. To qualify for an extreme risk protection order, you need to show that there is a significant danger of bodily harm to other persons or a significant risk of suicide by possessing a firearm. Those are the first 2 points there. So those are kind of exclusive of each other. It doesn't need to be both. You can have that risk of suicide without the danger to others, or the danger to others without that risk of suicide. That kind of stems into when there's a danger to others, an HRO or an OFP might be appropriate, or an arrest potentially if there are any actions that arise to criminal um, intervention. And that kind of risk of suicide is largely coupled with a civil commitment or some kind of interpersonal intervention on that person's part to get mental health treatment. To get an emergent, there's two types of extreme risk protection orders, an ex parte one and one that's issued after a hearing. To get that emergency relief in ex parte, you need to show an immediate and present danger of bodily harm or taking their life that's not new or life altering, right? That's the same thing for orders for protection, ex partes or HROs. It's just that taking their life part is, I guess, a little newer of a prong, but makes sense in terms of thinking about removing a firearm from someone. And then just you need to describe the types of firearms that that person has or may have, so that the judicial officer can make a very clear search warrant for the police to effectuate. At the hearing stage, the court has to consider several factors. And I think this is the main practice tip, to make sure you go through each one of these and think of creative ways in which you could prove this or provide evidence to the court, even on an ex parte basis. Having this information provided to the court is really essential. Judges aren't, judicial officers aren't allowed to go do outside research, so they need to look at the four corners of the petition when they're considering these things. So that really puts the onus on the person filing, or if you're helping a client file, to get this information in front of the judge. When I'm thinking of history of threats or violence acts, that can be in police reports or criminal complaints. You can kind of think of creative ways that there might be a history of threats or violent acts outside of that, and what evidence could support that, like text messages. I think this could be unique to an ERPO petition, where you can line up several order for protections to show that there is a history of violent acts or threats towards multiple people, where we're thinking of orders for protection. Judges are really focused on what has been done to that individual person, and less so if there are prior orders for protection for other people. Again, attempted use or threatened use of physical force, those types of threats or history, police reports, criminal complaints. Violation of court orders, I think, could require some digging for a practitioner to show the court. There are civil contempt actions that could show violation of court orders. There could be violations of probation, or that type of thing. You can also have settlements revoked for violating court orders in certain circumstances. I also think of charges for violating an order for protection or domestic abuse no contact order. So those are all going to come in different forms and might require some digging outside of just doing a criminal background search or something. It sometimes requires some digging into the case to find those. You might also see those with extensions of orders for protection or harassment restraining orders. You see other people lining up several violations of those court orders. So those can be some creative places to find violations. Prior arrests for violent felonies, I think that's fairly straightforward. That's going to be in police reports or criminal complaints. And it does just say arrests there. It doesn't necessarily outline that they have to be convictions. The next one is for convictions. And again, I think being creative, looking outside for violent offenses in other jurisdictions, if that's appropriate in your case. It doesn't have a requirement that it needs to be Minnesota based in any way. Conviction of cruelty to animals. Now that isn't a conviction, but I think it helpful information to a judicial officer might be if there are threats to cruelty or animal or other actions that never resulted in conviction, but it is more likely than not that cruelty to animals occurred. So that's, again, I think digging into orders for protection that have been filed against an individual, or other criminal charges that have been brought, and maybe there was a settlement to dismiss the cruelty to animal claim. So just a little more digging might be needed. And while that isn't a factor the court shall consider if it's not a conviction, I think it is helpful information and one that a judicial officer would want to know. Unlawful, reckless brandishing or display of a firearm. Again, I think this is going to have to get into be a little creative about where you find the information. It's not always going to look like a conviction to something like that. You might find it in a criminal complaint for a domestic abuse claim, or in an order for protection petition, or a harassment restraining order petition. It's not going to be as clear cut as just a conviction of cruelty to animals. So I think that kind of digging into past sets of circumstances can be really essential to giving the court a full view of this person's history and their need to have firearms removed for them. The suicide risks or mental illness, the Supreme Court did pass or issue a standing order about ensuring that mental health information and private medical information in these types of cases is confidential. So still putting that information in so that the court has it would be essential. And this is private information of people. And it might be a little harder for people like law enforcement officers to obtain. And so coordinating with family members or guardians in those circumstances might be the most appropriate way. This is really, ERPOs require a team effort in all regards, no matter who the petitioner is of a case, to provide the court with a full understanding of someone's history and the need for the restriction on their firearms and taking possession of them. And then prior extreme risk protection orders or other protection orders that the court should consider. I think this is a pretty thorough list. And just anything related to firearms can be very helpful for the court to understand why someone might need them restricted. I think on the flip side, I'll go to some practice tips. I've given a ton in the slide previous, but some practice tips about defending against extreme risk protection orders can be making sure that all those factors are considered and pointing out when there is lacking information on any of them, or there isn't any information for the court to consider. So the court there has a full view and idea that someone is prioritizing only one factor to the exclusion of the others. And that is something that can happen, right? If someone's in a mental health crisis and they've only had prior civil commitments, then there's really only one factor there, and it still might warrant an extreme risk protection order being issued. But as a way to counter an extreme risk protection order being issued, I think it's important to note that they don't have any violent history. Now, some other things would be to doing that digging and finding all the evidence in unlikely or unique locations, and if your client does have some positive interactions with firearms that you could note or you have evidence of, if they've gone through special training or they keep their firearms in a very safe way or safe location, I think that's helpful information to the court. Also, if your client chooses to like an ex parte ERPO doesn't issue, but you're going to that hearing and your client chooses to give their firearms to someone else in the meantime, that can be helpful information to the court that they're really taking the concerns raised seriously and wanting to show the court that they are a safe person with firearms. That those are, I think, kind of tips for counseling a client and moving them forward. At the same point, I think looking at the underlying reasons why someone was concerned that you had firearms, if it's a mental health situation and your client ends up getting mental health treatment and getting back on track, getting back on their medications, well, and an ex parte ERPO issued, it can be great at that hearing to show that your client is back on track, not having those suicidal ideations anymore, and ready to safely possess firearms or at least not have an order restricting that possession in place is more appropriate. And I think that's what judges or the point of the two-step process is really to allow people to take corrective action in between and allow judges time to take care before they issue a longer order. Similarly, if it's regarding a restriction on someone due to violence and there is a protection order put in place, maybe it's not continuing the extreme risk protection order as well and just letting the order for protection stand instead. So if there are safety kind of actions taken that undercut the reason for an extreme risk protection order, those can all be great options to negotiate and consider. So some kind of an outline of how the process works for an extreme risk protection order, an overview of that. So there's an event that takes place and then an ex parte is either issued or denied, and that's really based on whether there's an immediate danger to someone, to themselves or others. That's, again, not a new standard for judicial officers. I think they're fairly comfortable with making those calls. And then if it's an ex parte issues, then a warrant can issue and is executed. And that is to take possession of those firearms. Now, at the same time, a hearing gets scheduled and there's deadlines for all of these things to move fairly fast, just like orders for protection and harassment restraining orders. They're on deadlines because these are immediate issues. Once the hearing occurs, then the judicial officer is making a decision on whether the order remains in place or order, if the ex parte was denied, is issued, or if the final order is just flat out denied. And at that point, notifications would occur to agencies, and I have those notifications on a future slide. But I think that interim piece is really where I'm talking about if people get help for the underlying issues and show that there is no danger related to firearms moving forward, that can be eliminate the need for an ERPO on a long-term basis, or if there really no changes are made and there are still concerns, then that ERPO kind of moving forward makes a lot more sense. There are outlines in the statute related to extending an ERPO. We're getting a second one in the future, and it's not surprising. It's basically just related to if that continued need is still there. So the notifications that go out, and I guess these notifications would happen with an ex parte ERPO as well. But they forward it to law enforcement within 24 hours, and these happen fairly fast. Much court administration is used to it. They're there when necessary, and then within 3 business days, it goes to the National Instant Criminal Background Check System. And these alerts can be removed by court administration if the order is expired or dismissed. I think a huge part here and practice tip for practitioners would be to follow up with these notifications and make sure they're happening. If you're an individual filing an extreme risk protection order, it's making sure that these notifications go to law enforcement, that law enforcement is able to act on them, or you're coordinating with law enforcement. Hopefully it's not the first time the law enforcement agency is learning about this, as they might be a little shocked and confused on what to do, as these are fairly new, especially in a county that's never filed one, or with a law enforcement agency that's never filed one. They do know what to do with search warrants, though, so it shouldn't be the most shocking thing, I guess, at the end of the day. And then court following up to make sure that they're getting into the criminal background check system. I was just at a conference last week talking to someone from California where an individual was not allowed to possess firearms, but the order was never served on them, and didn't get into the criminal background system, and they were able to obtain a firearm, and they did unfortunately kill 2 people outside of a courthouse. And so following up on these notifications, even if you get the order, is really essential, and that's important for court staff too. I know we have some court staff here in this presentation. So and then if you're successful at getting an ERPO removed, making sure that you're following up with court administration and making sure that those notifications were removed, so your client's full rights are to firearms are restored, and they're not, going to purchase one and having a struggle there. So just some thoughts on the importance of this and following up on it. And that's the same for service. And things like orders for protection and harassment restraining orders, they're really only as effective as they can be if you make sure that the person is notified and their full protections are in place. So constantly reminding people not only that these are just pieces of paper and to do your own safety planning, but also that they're not really even pieces of paper until they're served and in full force. So I thought it was interesting to see how the outcomes have been in 2024 for extreme risk protection orders. Not, I don't think very surprising, is that primarily both an emergency order and a final order is granted. That's telling me that these are really being used in appropriate circumstances, and no one is really stretching the law here too much. Then 34 have been, the emergency order has only been granted. I think that what that's telling me is that people are either really addressing the underlying concerns of why an extreme risk protection order, why the firearms needed to be removed from them, or that these are getting used in conjunction with other relief, which made an ERPO no longer necessary after the emergency one was granted and the firearms were removed. So I think of situations where they're arrested and maybe not able to gain their firearms back, or there's an order for protection or other order out there that's preventing them from getting firearms back. Or the other thing is that they might have claimed a whole bunch of things and they weren't able to prove them once they got to a hearing. But I think that's less likely, as we're seeing primarily they're coming from law enforcement agencies. Now, the 34 could all be family members that filed and didn't do a great job of it at the end of the day. I didn't break down whose protection orders weren't getting granted, but I'm gonna guess it's likely that that no relief granted those 6 individuals were probably either family members or guardians who were just not using an ERPO as the right tool in their situation. Law enforcement officers are pretty darn good at filing petitions and requesting relief in emergency situations. And then no emergency order but a final order was granted in about 5. And what that is telling me is maybe the person who filed it didn't put all the information the judicial officer needed to consider in that petition. And that's again why, just a reminder, any information you have needs to be put down there so the judges have the right information and all the information in front of them to make full and complete decisions, especially when we're talking about emergency situations. In those 5, it really could have been the difference between life or death to not get those firearms taken away right away. So overall, I think seeing how many are granted is really telling us that this is a good tool and a useful tool, and people are seeing a need for it. And having just the emergency order issued in certain situations tells me that it can also be really addressing some of those other needs of people and getting them the mental health help that they need. So practice tips for after there is an ERPO decision. I think always safety planning. This is not a replacement for the safety planning that really needs to happen with clients when they're telling you they're in an extreme situation and their family member is either being suicidal or being dangerous with firearms. Getting them connected to a domestic abuse shelter or some other agency that can provide them safety planning tools, such as a mental health practitioner. Also getting your client help if they receive an ERPO and their firearms are removed for them and there is some mental health underlying concern, getting them the right help and support that they need to address those concerns. Or if they're having violent behavior, again, getting them some mental health treatment and to address that behavior is really essential to prevent this from becoming a reoccurring thing and overusing a process that is really not designed to address underlying concerns, but just address immediate safety needs related to firearms. Also related to that, I think following up and making sure the notifications are correct is really essential. Making sure things are getting served and getting to law enforcement so they have swift action. Coordinating with law enforcement to ensure their safety and that they're able to effectuate the orders in the safest way possible. If there are firearms in multiple different counties, then search warrants need to be issued in those counties. And so the coordination with law enforcement about where and what types of firearms there are will be essential to getting all of them when necessary. And then there was funding passed so that law enforcement can help store these firearms. I think if you are a law enforcement officer and looking to get more information about that, feel free to email me. I do have the links to grants that went out for that if you're a smaller agency wondering about that. So kind of all around, there's lots of options if you're getting pushback about law enforcement filing ERPOs for their safety or retaliation or because of funding and having to store them. There's lots of solutions for that and counseling any type of petitioner or respondent on these. Now, I know I flew really fast through everything, but that's because I wanted to leave a lot of time for comments and questions because I know these are new and I want to address whatever people are thinking. So I'm going to exit out of my screen and kind of take a look here at questions that are coming through. Please feel free to start sending them in.
I don't see any yet here, but one thing that I was wondering about, I wonder if it's just too new of a process yet, but if an order is issued, how does somebody go about asking it to be removed? Is there a process for that yet? Um, and what would that potentially look like?
Yeah, so the statute does outline how to request a hearing and that hearings are automatic too in these situations. And so they should get set on for a hearing by court administration once they have been approved or denied. So it's kind of outlined in the statute, getting into the nitty gritty of it all. I mean, I think we're going to have to be pulling up this statute and until we're very comfortable with it uh, to make sure that we're following it correctly. And I hearing from judges, they're doing the same thing, pulling it up, reviewing, making sure they're dotting their T's and crossing their I's. Or oh gosh, I flipped that around. But yeah, I think everyone's being very careful with it right now. And hopefully we'll see more and more of it, uses of it as it goes on. Um, so I can just start ranting about some other things. I think um, people wonder about the effectiveness of these. From seeing the stats in Minnesota on how many are issued before or with an ex parte and after, it seems to me that they're fairly effective because it seems to be addressing the right concerns of an emergency situation with firearms. Kind of nationwide, what we're seeing is there's no great data on if it actually prevents firearm death. And that's just because firearm data can be very political to obtain. And so getting just numbers on some of that stuff can be difficult. But I know there are some agencies working on that. Firearms are a lethality factor in domestic abuse situations. And so having an opportunity to be able to physically take those away, that I think is one of the biggest uses of ERPOs now. That is exciting to see and hopefully very helpful to people. Um, and just the additional, are there penalties for filing a false petition? There are some penalties in the statute. I think it's like a misdemeanor to file, well, maybe um, a, I don't remember off the top of my head. There are penalties. Um, the other thing that came to so yes, there are penalties, and then I'll move on to the next question, which is to confirm this is a civil tool, even though it's used by law enforcement, county attorneys. Yeah, exactly. This is a civil order. It's not criminal in any way. There can be criminal implications, such as the false penalties or violating the order by possessing firearms after you're not allowed to. And interestingly, those I think one thing that might have to get hashed out at the Court of Appeals or just through practice is what happens when someone violates, what it can get charged as there are if there's an order for protection and an ERPO in place and someone possesses a firearm, are you going to charge under the violation of the order for protection, which would stack on top of each other as those happen, or is it going to be an ERPO violation, which doesn't necessarily stack? So I think some of that kind of interplay of prosecutorial discretion would be interesting to see how it plays out. And thank you to listing the penalties that are in place, having those there. Any other questions? Are we seeing criminal defense attorneys representing their clients against these civil orders? I think important there is, right, it's a civil order, so you're not entitled to a public defender necessarily. Kind of anecdotally, what I'm hearing from people is, yeah, I'd probably be a criminal defense attorney. As a family law attorney, I also am stepping into that realm, right, with protection orders. I think they're fairly similar to defending against those as well, and kind of similar thought processes. So it could be that as well. But I've also heard from plenty of criminal defense attorneys and family law attorneys that they have no interest in kind of learning about a whole new law. They have their bread and butter, and tossing this in there is just like a whole nother statute to learn and everything. So I think there's some hesitation to that. And obviously, with only 111 out there, it's I don't think anyone's going to get super comfortable with it super fast. They're just not coming in at that rate. I do think we're going to see a bit of an exponential growth as certain police departments get comfortable with it, or as the word gets out that this is a tool that's available, it will become more and more used. And one of the concerns prior to this coming into place in January of 2024 was, is this going to completely overwhelm, is this completely going to overwhelm the court system? And with 111, no, it hasn't. So I think that is a good thing. And I know judges have been, there were trainings on this initially, and it's really they're sussing it out as it goes. I know there's a lot of conversation behind the scenes between judges when they come in, to share what they're seeing, so that even if it's the first time it's coming in front of a judge, they have some knowledge about what's happening. Judges are so great about that and getting familiar with things. And yes, in the chat, information about how to request to terminate an ERPO has been put in there. And there are judicial forms, yes, this is a great point to make, available to anyone who wants to terminate the ERPO. And I believe there are forms available to file one as well. So taking a look at that, and hopefully it would jog some thought processes on what information should be included. Anything else coming to mind from people? Questions? Has anyone here done one yet? I think if you have comments on that, that might be helpful to see. Talk more about presenting protected mental health information to the court. Is it only viewed by the judge necessarily? I don't think you can guarantee that, right? If you file, what you should be doing is filing it under a confidential information form, right? Those are on the court website as well, if you're not familiar with them, so that it's not available to the public. But a respondent should be able to see anything that's filed in these cases. I think one of what comes to mind is, how would law enforcement get some of that information if they're going to be the one filing? And that's where I think that's working with family members, working with mental health providers or hospitals to get the right information, so that the judges have the right information. And so if you're asking about keeping it from a respondent, I don't think that would fly. But I do think it should be filed under a confidential information form as medical information, and thus protected from individuals. outside of the court case. The other thing that comes to mind is, what if you're putting some of that like diagnoses or information about someone's mental health in the core petition itself and not just supporting documents? And that might be where we're going to have to learn some tricks of the trade and do our judges going to seal those petitions or not? And I think it depends kind of largely of how much information is in there. And yes, the Supreme Court issued that standing order related to ERBOs, and just documents in general, private documents. If you want a copy of that Supreme Court standing order, one, it's fairly easy to find over Google, or feel free to email me. Happy to share it. Any other questions jumping out to people, or thoughts, concerns even?
I don't see any others coming through the chat, so while we're giving people one more chance to jump in here, I'll just say thank you for sharing this information with us. This is really helpful to have for this relatively new procedure that we're dealing with. So I appreciate your time and expertise today. I'm keeping an eye on the chat. Last call for questions here, and if not, we'll go ahead and conclude here.
And I would just add, I'm open to questions anytime if you want to talk through some of these issues, or if something comes to mind. I'm trying to keep a pulse on what's happening with these orders, with up-to-date information. So I'm happy to chat through at any time. And I thank you all for being interested and showing an interest in this new law, and being willing to learn a little bit about it, as I think it's an important tool for us to use to help hopefully make our community a little safer, and prevent and de-escalate these difficult situations.
Great, thank you so much.